Welcome to the Tuscarawas County Divorce Clinic, brought to you by Southeastern Ohio Legal Services. Southeastern Ohio Legal Services provides services for people that need help to protect their livelihoods, their health, their homes, and their families. We provide information on how to get into court and what to do once you get to court. We also provide easy-to-complete legal forms. We have 6 offices throughout southeastern Ohio, including an office in New Philadelphia. This presentation will cover 6 topics. First, we will discuss alternatives to divorce. Second, we will give an overview of the divorce process. Third, we will talk about preparing court documents. Fourth, we will talk about local rules. Fifth, we will talk about filing the documents. And sixth, we will talk about hearings and trial. The first topic is alternatives to divorce. We will talk about 4 alternatives to divorce. The first is dissolution. Just like a divorce, a dissolution ends the marriage. It differs from a divorce because both spouses are in total agreement about all issues before it is filed with the court. The second alternative to divorce is a legal separation. It does not terminate the marriage. The third alternative to divorce is an action for necessary support. To look into child support, you can contact the Tuscarawas County Child Support Enforcement Agency. It is at 154 2nd Street Northeast in New Philadelphia, and its phone number is 330-343-0099. Finally, if you have problems with family violence, you can seek a civil protection order. A civil protection order can prevent your partner from having contact with you and/or your children. If you think this is an issue for you, you can call Harbor House at 330-364-1374. You can also talk to the Tuscarawas County Victims Advocate, Deb Baker, at 330-365-3258, or Compass, which focuses on sexual assault victim support. Their phone number is 330-339-1427. Next, we will give an overview of the divorce process. There are several steps of the divorce process. The first step is preparing documents. Fill-in-the-blank documents are available from the court's website, SOLS's website, seols.org, and the website of the Supreme Court of Ohio. After you have prepared the documents, you file them with the Clerk of Courts. Next, the clerk will serve your spouse either through mail or publication with the documents. Fourth, the judge will issue any temporary orders for your case. Next, your spouse will respond in writing in what is called an answer. After that, the judge will issue a scheduling order or refer the case to mediation. After that, a pretrial conference will be held, and then there will be a final hearing or a trial. After that final hearing or a trial, there will be a final order, which is normally called a magistrate's decision. The parties will be billed for costs, and to give you a general sense of the time frame, this will normally take 9 to 12 months without children and 9 to 18 months with children. Next, we'll talk about preparing the court documents. There are 2 types of documents that we will discuss: documents that begin the case and additional documents needed in certain circumstances. First, we will talk about documents to begin the case. The first document is the Domestic Relations Case Designation Form. This provides information about the case to the clerk. Second is the disclosure of personal identified information. This provides personal information to the clerk that will not be released to the public. Third is the complaint for divorce. This is the document that starts the divorce case. It provides the court and your spouse with basic information and a list of what you want the court to do for you. Next are the instructions for service. These instructions tell the clerk how and where to deliver the court documents to your spouse. Next is the affidavit of property, which must be notarized. After that is the affidavit of income and expenses, which also must be notarized. There's also a private health insurance questionnaire. If there are children from the relationship, either children that were born during the marriage or children that you and your spouse had together before you were married, you will need to file additional documents. These include the affidavit with child parenting information, which contains certain information about the children, the application for 4D services, which applies for child support services with the county's Child Support Enforcement Agency, and the Child Support Computation Worksheet. The software for that worksheet is available at the County Law Library. Finally, if you do not have the money to pay the filing fee up front, you can file an affidavit with the court to waive prepayment of court costs. You will pay the court costs at the end of the case. Next, we will talk about documents that are needed in certain circumstances. Depending on your circumstances, you may need one or more of the following documents filed. An ex parte motion for temporary orders. This asks the court for certain orders that will remain in effect until the end of the case. You can also file an affidavit that tells the court why you need or want temporary orders. Finally, you'll need a journal entry, which is the form you want the judge to sign to grant the temporary orders. Next, we will discuss local rules. You must follow the court's local rules when filing court papers. These rules include: you must put the full names and addresses of both parties in the caption. You must put your phone number either in the caption or at the end of the document where you sign. A complaint that starts a case and a motion that reopens a case must have a request for service that asks the clerk to mail it to the other party. Other documents must have a certificate of service at the end. The certificate of service says that you mailed it to the other party and the address you mailed it to. You must sign all of your pleadings and motions before you file them with the court. You must staple documents if they are more than 1 page long. The pages must be in the correct order. Finally, if a document needs to be notarized, have it notarized before you get to the clerk's office. Next, we will talk about filing the documents with the court. When you file a document, you'll need several copies. The clerk keeps the original. You will want 1 copy for your records, 1 copy for your spouse, and 1 copy for the Child Support Enforcement Agency if you have any children with your spouse. You'll file the documents with the clerk of courts, which is at the Tuscarawas County Courthouse on the 2nd floor of the annex. There is a fee to start a divorce case. If you and your spouse do not have children, the fee is $255. If you and your spouse have children, the fee is $345. These amounts change, so check the court's website or talk to the clerk of courts before you arrive at the courthouse. As I mentioned before, you can file an affidavit with the clerk to ask the judge to let you pay the costs at the end of the case instead of at the start of the case. To file documents with the court, you go to the clerk of court's office, and the clerk of court will stamp each document. The stamp shows the date and time of filing. The clerk will give the case a case number and assign it to a judge. You will get a copy back from the clerk. Remember, if you move after you file the lawsuit, you must submit your new address to the clerk of courts in writing. Finally, we will talk about hearings and trial. Before you have a hearing or trial, you will want to review your documents. Know clearly what you want the judge to do. Identify and talk to witnesses. Bring documents such as bank statements, land records, and car titles that are relevant to your case. Arrive early. Do not be late. And dress appropriately and be respectful to the judge, your spouse, and everyone who works for the court. If your spouse does not show up at the hearing or does not oppose your complaint, you can file a separation agreement with the clerk. The forms are available on the court's website. If your spouse opposes your complaint, use your complaint as an outline and tell the judge exactly what you want him or her to do. Have witnesses testify on your behalf if the testimony is helpful. More information on what to do at a hearing is available under the Get Help tab at souls.org.